Hi, it's Jenna Scott, and I'm going to be reading about maintaining proper IRS relations from Carlton Weiss's Concise Trustee Handbook circa 2008. Maintaining proper IRS relations. Last but not least, due attention must be paid to the Internal Revenue Service, for they are the lawful legal entity duly authorized to collect association dues, income taxes from 14th Amendment citizens and other persons volunteering and availing themselves of the privileges and immunities regarding non-payment of debts in the system implemented under former H.J.R. House Joint Resolution 192, 12 U.S. Code subsection 95A, and 15 U.S. Code Chapter 41, subsection 1602, C, D, and E. The participants are considered as a debtor-creditor in a Social Security association, unchartered, unincorporated commune, whereby each person insures everybody else in the association by agreeing never to demand payment for debts. It is under this volunteer arrangement that these persons become primarily a U.S. citizen, secondarily a state citizen, subject to Clause 1 of the 14th Amendment, while the literal 10th Amendment rights are forfeited. Footnote 201. Persons under this system have only relative rights to life, liberty, and property. Their natural rights are converted into privileges and immunities and civil rights. As debtors, they have no absolute literal property ownership, for it has thus been converted to mere usership. Footnote 202. Plainly put, IRS taxes serve several functions, but principally as dues for the privileges and immunities associated with participating in the Federated, Unincorporated Interstate Banking Association for the non-payment of debts. Footnote 203. What's more, the collection of income taxes is crucial to maintaining order within the association, more so than for any proposed funding of the association. Footnote 204. But that has no bearing on a properly created and administered express trust. It is well settled that a trust created by parties not availing themselves of such privileges and immunities is not illegal, even if formed for the purpose of limiting or avoiding taxes altogether. Footnote 205. Nor is the express trust subject to federal excise taxes imposed on corporations. Footnote 206. Nor is an express trust taxable merely because it possesses all the accessory powers possessed by corporations. Footnote 207. Nor can the dignity of its trust instrument be set aside simply because a, quote, tax benefit, end quote, results, whether by design or by accident. Footnote 208. Frankly, unless it incurs a tax liability in the United States via a valid forum clause in a contract, membership in the unincorporated banking association becoming an employer, employee, or worker or corporate entity deriving income from corporate stocks or physical franchises, accepting other privileges and immunities under the 14th Amendment, or availing itself of any other benefits of the public trust, invoking the doctrine of reciprocity, it has nothing to do with the IRS. However, as it might stand as a beacon of organizational liberty, the IRS has a reasonable interest in making sure that the express trust example does not upset collections and, most of all, compliance. The IRS thus takes every precaution to shoot down trusts of any kind which even hint at having origins lying outside of its jurisdiction, i.e., the, quote, other property, end quote. It is interesting to note that the IRS taxpayer relationship by operation of law is that of beneficiary, cestuique trust, to trustee. It is a classic resulting trust. The taxpayer is presumed to be a trustee, hence he is legally he is legally obligated to report and make distributions to the party having a legal right to certain amounts pursuant to the trust bylaws, i.e., the U.S. tax code. It becomes understandable then that the IRS would construe every instance, no matter how rare, of a non-statutory trust condemned in court as being attributable to some purported inherent unlawful nature of non-statutory trusts in general. Hence the classification of, quote, abusive trust, end quote, though any trust, parentheses, statutory or non, express or implied, resulting or constructive, end parentheses, which abuses the fundamental principles upon which equity rests, is technically abusive. Yet they never speak of them. The reader should therefore be keen to know how to discern good information from dis- and misinformation. In the event the IRS takes an action against a purported common law trust or pure trust, aka poor trust, it is generally a lawful action, actually in response to some unlawful activity on the part of the parties or defect in their contractual relations. Your author has never seen an action taken against a properly drawn express trust, i.e., one drafted from the perfected language and form of the, quote, best legal talent, end quote, footnote 209, to which the power and superiority of the express trust is attributed. Even in those cases, a thorough analysis of jurisdiction, such as the one treated in the previous section, sheds light on the blatant limitations of the IRS's and the courts in general jurisdiction. The fact that they managed to establish subject matter jurisdiction and personal in rem jurisdiction attests to the ignorance of the defendants, and indeed, personal jurisdiction usually would never have been obtained without the defendants' unwitting permission. Footnote 210. It is no secret that all actions of the IRS are commenced as proceedings in admiralty. Footnote 211. I'm going to go ahead and finish this up with the conclusion in this reading. The only way to thrive in 21st century America is to, quote, own nothing and control everything, end quote, privately. And though any trustee is the legal owner of the property in trust, the trustees of express trust do not experience the incidence of personal ownership due to properly limited liability via trust instrument and the cardinal virtues of the trustees. It is this limited liability that makes the express trust no less than the corporation, but it is the latitude of choice of whether to function in the common law venue with absolute rights in commerce under the general law merchant or in the Roman civil law venue with only relative rights in commerce under private international law that makes the express trust, inter alia, far superior and profitable. Under the aegis of the express trust, the trustee is clothed in a veil impenetrable but from within. This suit of armor is the trust instrument which molds to the trustee in all his good faith dealings on behalf of the trust, fully compensating him for his services, privileging his use of trust property, and enabling his exercise of creativity in business endeavors, all without the excessive weight of inquisitorial legislation. The greater latitude afforded under express trust manifests itself in a number of ways, one of which is the prosecution of claims and commercial liens wherein the trust acquires for value the account of a debtor, and the trustee utilizes the trust's qualities in order to effectively collect the debt owed. The trust brings with it a form of professionalism and authority which enables debt to be collected honorably. And when one is trustee, he is in a fiduciary position generally looked upon with respect for the integrity inherent in the position. This has always been the case, except where the power has been abused. But even so, history is clear that there are far more abuses of power via corporations than express trusts. Footnote 212. Given the statistics and the fact that all governments in 21st America are corporations themselves, it becomes clear that the extensive recognition given to corporations by the state is simply because of the special interest relationship between the two. In a way, it is the same relationship between the John and the prostitute, footnote 213, for it is always in the best interest of the prostitute to take measures to keep the John in business. This is done in order to indirectly protect her own job security. This is also the underlying cause for much of the negative sentiment toward express trusts operating in the statutory world. It is this relationship that has bred the irrational view that, quote, some trusts have been created independent of statute, some non-statutory trusts are said to have done harm, therefore public policy demands that hereafter all trusts shall be regulated, end quote. The irrationality of this becomes more apparent when the syllogism is paraphrased thus, quote, some lawyers have been presidents of the United States. Some presidents are said to have done harm. Therefore, public policy demands that hereafter all lawyers shall be prohibited. The bottom line is that the express trust relation is the most effective means to owning nothing while controlling it all, and when utilized properly, it affords its participants with all the ingredients of legal health and commercial wellness. It is also true that no matter how many arguments are made against the express trust, the learned reader will always see through the propaganda and spin, knowing the state's nagging concern is the utter lack of in rem jurisdiction over express trusts. Possession is 9/10 of the law. At the end of the day, in rem jurisdiction remains in the private venue, i.e., with the trustee, pursuant to the private contract between he and the settlor. So, from natural deduction, it should become clear that the express trust can really only fail due to some misgiving or impropriety on the part of the trustee. The trustee must therefore trust himself. And that is the end of the book, or not the entire book, but just the chapters. And now we are going to look at the list of sample forms. I am not going to read all of the sample forms in this recording. If you would like to have a reading of all the forms, you can send a request to me through the link that's provided in the description. If there is a link yet, there will be someday possibly. You can request a reading, the recording of the sample forms, or you could have AI read it for you, or you can read it yourself. But the forms that are included are, on the left, we have the form name and then the form description on the right. So we have the asset sale agreement, and that's an agreement to buy assets by trust. Assets to be bought with silver gold from trustee in an individual capacity. Assignment of bank account. This form assigns a bank account and all deposits in it over to the trust for value received, and also serves as notice to the bank to act on the assignment accordingly. Assignment of copyright. This form provides an outright assignment of a copyrighted work to the trust. Assignment of wages. Under this agreement, a person's right to employment wages is transferred to the trust. Attorney retainer agreement. This is a retainer agreement with a special jurisdictional understanding, excluding attornment with services provided under reservation of rights and with protection against minimum contacts. Authorized rep contract. Contract between trust and authorized rep, setting forth terms and conditions of the position. Authorized rep introduction. Letter of introduction. Introducing authorized rep to third parties with whom authorized rep will be in contact in regard to certain trust affairs. Bill of sale. Bill of sale, property of whatever kind. Seller is trustee in individual capacity. Buyer is trust. Transaction completed by authorized representative on behalf of trust. Bond basic. This form is a bond that secures the indebtedness of the principal and lawful money of the United States. Bond indemnity. This form is a bond that provides for a principal indemnifying the trust or trustee of all risks and liability contingent upon a certain event. Independent contractor agreement. Provides for a short form independent contracting agreement for virtually any type of services which can be performed by an independent contractor. Use this form to establish a contractual relationship with someone who is performing services for the trust. I.R.S. Form SS4. This form is to be filled and submitted to the Internal Revenue Service for issuance of an employer identification number, EIN, for banking purposes. Lease with option to buy. This agreement provides for a lease of trust property with an option for the renter to buy the property for silver or gold. Limited power of attorney. Limited power of attorney authorizing third party to act on behalf of the trust. Management agreement. Provides for a management agreement for either a business, services, or other matters between a management trust and client trust. Meeting, annual, minutes for the annual meeting of the Board of Trustees. Standard businesses discussed. Meeting, notice, regular notice of meeting of the Board of Trustees. Meeting, real estate assets. Minutes of meeting wherein board resolved to accept real estate into trust corpus. Meeting, revocation of beneficial interest. Minutes of meeting wherein board resolved to revoke the beneficial interest of a beneficiary in trust. Non-recourse promissory note. This note establishes a legal obligation but does not make the trust the note liable except for any collateral which was pledged. Notice of assignment and instructions for payment. An assignment of a check or funds usually occurs by endorsement, but notice can be given to employer of assignment instructing that payments are to be sent directly to trust. Notice of private sale of collateral. Notice given to debtor by the trust that collateral will be sold privately on a set date and time, and that debtor will be liable for any unpaid balance. Offer to buy automobile. Like any property deal, a person can submit a formal offer to the owner of a car. Upon signature, this becomes a binding agreement for the sale. Proposal to exchange property. Proposal to exchange property into the trust in exchange for capital interest. Thank you for listening, and that is all in this particular section.